that you're giving up by waiving your right to counsel. I'd be happy to do that.
That wasn't what was discussed last week in the hearing, sir.
Last week's hearing was called for your competency. You submitted to a competency evaluation on the court's own motion. The report was brought back, and the report was discussed last week, and you were found competent to stand trial. With that finding, I readdressed the issue of your attorney, and you refused to submit to any questions that I need to ask you with regard to your waiver of right to counsel, and left the courtroom.
Actually, I believe, sir, I made it very clear that I was unwilling to waive any of my rights.
Well, sir, one of the rights that you have under the Constitution is the right to be represented by effective counsel. You have Ms. Donahue-Angler here as your counsel appointed by this court. If you'd like to waive...
But, sir, I have to object.
Sir, if you'd like to waive her as your counsel, meaning give up your right to be represented by counsel and submit to this court the questions that I need to ask you so that I can make sure you understand that, then I'd be happy to do that. Is that what you'd like to do here today?
No, sir. This whole process, all these procedures, all these court hearings have all been mishandled. I can't honestly expect to get even remotely a fair trial out of this. Out of all the egregious law violations that you've committed right there from that bench on the record and have admitted, all these forcing me to do things against my will, forcing me to take legal counsel against my will, choosing pleas for me. This is all unlawful, sir. Until this time right now, I have never even chosen a plea. You chose that for me, which is unlawful. It's a violation of 28 U.S.C. 454. It's practicing law from the bench. I don't understand how anybody can blatantly break the law under the guise that they're going to hold me accountable for alleged violations. It doesn't make any sense. The ends don't justify the means. I can't possibly expect to get a fair trial on this, sir.
Okay, sir, your plea was entered pursuant to Criminal Law 11 because you refused to enter.
I did not refuse, sir.
Right to enter a plea.
I did not refuse, sir. I was addressing the jurisdiction of the court, which you refused to
represent you because I felt that you needed an attorney to represent you. Now I've given you.
But that's not your choice, sir. That's my choice as a defendant. I
protect your constitutional rights, Mr. Killoran, and now I've given you 3 opportunities to waive your right to counsel and proceed as your own attorney if you'd like to do that, or as your own representation if you'd like to do that. But what you've done is refused to go through the questions that I'm required to ask you to make sure that you're waiving that right to have counsel and that you're doing that knowingly, intelligently, and voluntarily.
This is absurd, sir.
Well, it's the law, sir. So if you don't want to do that, we're going to proceed today. You're going to go up proceeded, represented by Attorney Angler.
I object, sir. I object. I don't have any relationship with this person. This person does not know me whatsoever or my situation. I've never even had a conversation regarding any of the situation with this person. They only tried to introduce themselves, and that was it. I don't want to have anything to do with this person. I made that pretty clear.
We start here today to talk to your attorney.
I'm sorry?
Would you like an opportunity before we start your hearing here today to speak with Ms. Angler?
No, because I don't intend to be represented by Ms. Angler because she's already committed fraud, and this is ridiculous. I have the right to
be represented by Ms. Angler, then you need to submit to some questions so that I understand that you're waiving your right to counsel.
I waive none of my rights, sir.
Okay, so that's the problem, Mr. Killoran. You're telling me you don't want counsel, but you don't want to waive your right to counsel. So what am I supposed to do with that, sir?
Not force me to take counsel.
Okay, if you don't want to have counsel, I'll ask you a few questions about waiving that right to counsel.
I don't waive any of my rights, sir. See, you're expecting me to waive my rights. I shouldn't have to waive any right. I should just be able to make the choice that I don't want to be represented by somebody that I don't know and doesn't know me.
All right. What we're going to do is we're going to proceed with this hearing here today. Okay?
Well, this is unlawful, sir.
Opportunity to waive your right to counsel.
I object. This is unlawful.
What is your objection?
Really? I've made it pretty clear, sir, that throughout all these proceedings and this whole entire process, I have not been given the opportunity to actually make my own choices. I've tried to address situations with the court that you failed to address, and you wanted to push those forward and ignore those issues and choose a plea for me. That's unlawful, sir. That's a violation of federal law.
Right. Are you requesting that Ms. Angler be removed as your counsel?
Yes.
All right. And I'm required to determine if you're making that request knowingly, intelligently, and voluntarily. So I'm going to...
That's fine, but just let me clarify as a caveat, I waive none of my rights. So you can ask me the questions, but by no means presume that I'm waiving any of my rights, please.
I need to understand. understand you do have the right to be represented by counsel. So you are in fact waiving the right to counsel if you have Ms. Angler removed from your case.
No, I'm not, sir. I'm just choosing not to take counsel. There's a difference.
All right. I'm going to explain some things to you, the charges against you, and certain rights that you have in these cases. I'm going to ask you some questions to make sure that you understand and appreciate the disadvantages of proceeding without an attorney, okay? You willing to submit to those questions, sir?
If you ask the question, sir, I'll answer if I feel fit.
All right. In this case, sir, case number 20, CRB 00832, you've been charged with one count of telecommunications harassment. That's in violation of Zanesville City Ordinance 537.10A1. That's a misdemeanor of the first degree. In order for you to be convicted of this charge, the Zanesville City Law Director is required to prove beyond reasonable doubt that you did knowingly make or cause to be made a telecommunication, or knowingly permit a telecommunication to be made from a telecommunication device under your control, and that telecommunication was made with purpose to harass, intimidate, or abuse any person at the premises to which the telecommunication is made. That is, whether or not actual communication takes place between the caller and the recipient. If you're convicted or plead guilty to telecommunications harassment, each count is punishable by up to 180 days in jail, up to a $1,000 fine, up to 500 hours of community service. Do you have any questions about the nature of the charge against you or the possible penalties that I've just explained?
No, sir. I've read them fully. I'm fully aware.
With regard to your rights, do you understand that you have the right to assistance of counsel for your defense?
Sir, I understand all of my rights.
While you have the right to represent yourself, there's a strong presumption against your waiver of any constitutional right to counsel. That's because your lawyer is trained in the law and has experience and knowledge in the entire legal process. Your lawyer can advise you regarding elements of the charge against you. Your lawyer can advise you about any defenses you may have. Your lawyer can advise you of circumstances and mitigation of the charges against you. Your lawyer has access to legal research materials such as the law library, legal research services, that put a lawyer at an advantage in researching the law and precedent that apply to your specific case. Your lawyer is not subject to any no-contact orders and is permitted to interview potential witnesses with whom you are currently prohibited from contacting. Your lawyer has the experience and knowledge to subpoena and question witnesses on your behalf. Your lawyer has the experience and knowledge to properly present other evidence in your defense. Your lawyer knows the rules of evidence and what evidence can and cannot come in at trial. Your lawyer knows how to properly object to any improper questioning at the time of trial. Your lawyer knows the rules of criminal procedure, including the rules about requesting a mistrial, proper grounds for a mistrial, and how to proffer evidence to protect the record for your appeal, and how to move for a judgment or acquittal. By proceeding without an attorney, you understand that you're giving up your right to an experienced lawyer's advice and counsel in all these things that I've explained to you.
Sir, let me state it this way. I have the evidence I need. I don't need legal counsel. I made it very clear in my affidavit I submitted last week.
Do you understand all the advantages that I just explained to you about having an attorney represent you?
I'm aware of the advantages, sir.
You understand by asking Ms. Angler to be removed as your counsel, you're giving up those advantages?
No, sir. I'm just giving up her as my legal counsel. If I choose to require those abilities or whatever you want to call them, then I can find a different attorney. But this particular attorney right here, this person, I do not want representing me.
All right. Well, we're going to go forward with the hearing today, sir. So are you prepared to represent yourself today?
Yes, I am.
All right. You further understand that proceeding without an attorney because you're not trained in the law, that you may be unaware of certain rights that would be of your advantage to assert, and that you may lose those rights if you do not properly assert them. Do you understand that?
No, sir. Because the only way that can be done is if I'm tricked into...
He's here to trick you, Mr. Killoran. I'm just asking you if you understand that your attorney may know things in the law and rights that need to be asserted that you might not be aware of.
That's nice, sir. I think at this point it's kind of a moot point. I'm ready just to establish what the facts and the truth is to get it on the record so we can get this done and over with so I can clear my name of these ridiculous charges.
Right. You understand that proceeding without an attorney that you won't be given any special treatment or explanations by the court. For example, if you ask objectionable questions or unable to properly introduce evidence at the time of trial, there's not going to be anybody
I'm aware of that, sir.
Okay. Lastly, sir, I'm going to advise you that if you are disruptive in the courtroom during your trial at any point, and the trial can't be reasonably conducted because of your conduct, the criminal rules of procedure do allow me to end your self-representation and proceed with this trial in your absence. Do you understand that? You need to abide by the rules of the courtroom, abide by the law here.
Sir, I'll act respectfully. I'll state it that way.
Okay.
But I expect the same in return.
I've always been respectful of you, Mr. Coleman.
And honesty as well.
Do you have any questions, sir, about anything that we've gone over here today?
No, just want to reiterate that I don't waive any of my rights, and all of my rights are reserved. So there are no presumptions. I don't want you to get any misunderstandings.
Is that right?
Excuse me?
You don't want to proceed with Ms. Angler as your attorney, is that right?
I want to move forward and represent myself, sir.
And has anybody coerced you or forced you to represent yourself in this case, sir?
No, sir.
All right. What I'm going to do is I'm going to appoint Ms. Angler as your standby counsel. That means she's going to stand by. She's not representing you. You can represent yourself. If you have any questions about the law or have any questions about entering evidence, she's here at your disposal. You can ask her any questions, okay? She's going to be here present in the courtroom as your standby counsel, but you have the right to represent yourself here today. So you can have a seat, sir.
And I don't want there to be any misunderstandings that there's no, by any means, consent of mine to accept her as my legal counsel.
She's appointed as your standby counsel, sir. That's the end. Mr. Killoran, since we've gone through those questions...
Excuse me, sir, if you could address me accordingly. My name is Brandon. Please don't address me as Mr. Killoran.
I have this form. This is about you not wanting to proceed with counsel. I need you to review that form. It goes over everything that we just talked about.
And why would I have to sign this, sir?
Because, sir, you want to proceed without counsel.
You've already accepted that by allowing me to sit here.
Do it in writing.
So after accepting my ability to represent myself, you're going to have me sign something after the fact? You should have presented that prior to accepting me to represent myself, sir.
Sir, we're doing it all together right now. We have to do it in writing. Okay? We've done it on the record. Now we do it in writing and we can proceed.
Well, sir, I'm already sitting here. I'm already representing myself. There's no need for me to sign that document.
There is.
No, there's not. I object.
To what, sir?
Just signing away any of my rights. I've made it very clear I'm reserving all of my rights.
But you want to proceed with self-representation, which means you're waiving your right to counsel, and that's all that form does.
No, it means I want to represent myself. You're trying to misconstrue the facts. I'm not saying I don't. No, this is ludicrous.
All right. I'm going to take a brief recess. You need to take a look at that form, and if you need to talk to Ms. Angler about it, you can.
So the judge has effectively abandoned ship.
No, he's taking a short recess so you can discuss it with your attorney.
Well, you all abandoned ship. You all walk out of the courtroom. It's abandoning the case.
He just has to do
Please.
certain things.
Please, it doesn't matter.
Sure.
I don't know why you're forcing the issue.
I'm here, you know, Brandon, I'm here because the court told me I gotta be here.
It doesn't matter. I don't
And if
want
I
you
don't
here.
show up, then he can throw me in jail.
Then
for
that's between you and
contempt.
him. That has nothing to do with me.
Sure. So here's my notes
No, that's nice.
on the issues that are actually gonna be raised here. This form, you can read it, review it. This is just putting in writing what you've already gone through here today.
I've made it very clear.
You have. You really have.
Yeah.
You have. We all know and
And
understand.
apparently none of you all understand what I'm saying.
No, I think I think you have made it incredibly clear that you don't want me or any other attorney to represent you, and that's totally your right.
But
And
yeah,
that's-
you're
and
still
that's
standing in
great.
front of me, and why is that?
Because if I don't stay here, the judge is gonna be mad at me, and I don't wanna go to jail. My kid's got a football game tonight, so I got other stuff to do.
So therefore, you're going to force me to.
No, I'm not forcing you to do anything.
You're standing here in front of me.
Because I'm just giving you my notes about the case.
I don't want your notes. I don't want anything from you.
And we know you don't want to have an attorney. What this form is just to put that in writing.
I don't need
We've
your
already made
opinions.
the-
I don't need you to speak to me. Please just go away.
Okay, I put on the record that you are refusing then to talk to me. The judge just made that request to review the form, so I'd let you know. It's just putting in writing what you've already
That's
told
nice.
them.
Just please go away.
All rise, please.
And maybe see. All right, Mr. Killian, have you had an opportunity to take a look at the form?
Please, sir, if you could please address me appropriately. I've asked multiple times for you to address me as Brandon.
Have you had an opportunity to look at the form?
I've sat here while you abandoned the courtroom, sir, yes.
And are you going to sign the form this morning?
No, sir, because I'm not waiving any of my rights. I don't know why you want me to waive my rights when I've said explicitly that I do not waive any of my rights.
Well, we've gone through the waiver of your right to counsel on the record. I will note for the record you refused to do that in writing, although you've done that on the record in compliance with the criminal rules. So
If I may, sir, if I may object, if you could please show me where I'm required to waive my right to represent myself in the law, or if you could cite that law for me, please.
I'm not going to cite any law for you today, Mr. Chairman.
Okay.
We're going to proceed with the state case. Do you have any opening statements?
No, Your Honor, the city would waive.
All right, Mr. Killian, do you have an opening statement to make?
Yeah, I do.
Okay, you may proceed.
Well, unfortunately, there is no jury here of my peers to make a decision in this trial. So I guess that'd be safe to say that the decision would fall on your shoulders. So it's unfortunate throughout all these proceedings, throughout the arraignments, throughout all the hearings, and get to this point that we are in today. There seems to be no real cognizance of the actual law. It seems like the laws are arbitrarily picked through and chosen which ones want to be followed and enforced and which ones don't. All in a supposed guise to hold me accountable for wanting peace and quiet at my residence where I live. I never thought in a million years I'd be in this position where I'm at today, because it's pretty simple. The laws are pretty straightforward. That's not why I'm here today. I'm not here because of a law violation. I'm not here because of some ridiculous accusation that was made against me. I'm here today because the law is being ignored. I'm here today because the law has been ignored for some time now, and this is just another chapter in the book of harassment and intimidation that I've been subjected to over the past 26 months, particularly by the Zanesville Police Department and individuals like Detective Tom Porter, Chief Corey, Lieutenant Schilling, and many others have gone on the record to prove their blatant disregard of the law. And the reason why I'm here today is not because I committed any crime or I hurt someone or I did something that would even constitute this kind of treatment. I'm here today because the law is being ignored, and the reasons that I have initially contacted the city and the police department, which got us to this point, is being ignored. So that'll all be established with evidence and my sworn testimony. You know, and honestly, at this point, with all the egregious law violations that I have evidence of, it really doesn't matter what this court decides, because it's going to be up to the next court that I appeal this any decision this court makes too, that we will go through and look at all of the law violations that have been not only perpetrated here in this court on the record, but by police officers sworn to enforce law and protect the community. That's not what's happened. This is exactly why I'm here today, and I'm here to prove that's why I'm here today. This has nothing to do about me being a violent person, which I'm not. This has nothing to do with me abusing an officer or police department or whatever, because that's absurd. When someone needs the law to be enforced, who else are they supposed to call but law enforcement? So the best that I can hope for today is that we're honestly interested in gathering the truth and facts, and not try to twist and manipulate every step of the way just so a person or individual or a man like myself could be silenced, ignoring my individual rights, ignoring my God-given rights that are secured by the Constitution, that are not supposed to be infringed on whatsoever, but have been. Property has been stolen from me. I've been subjected to for lack of better terms, I've been subjected to a terroristic style of treatment, all because I've been complaining about noise that is in violation of local law. Now, if any of you think that's okay, I certainly pray that God has mercy on you and might reveal to you some truths. That way you might have some understanding in realizing the extreme, egregious violations that have been made to get us to this point today, where we're at. And again, how can I possibly have a fair trial with all of these blatant law violations? It seems absurd to me, but I guess this is the day and age we live in, where it doesn't matter what the truth is. It doesn't matter what reality is. It only matters what can be proven on paper, or what someone that works with the very organizations that are working against me say, because obviously they get the benefit of the doubt, not myself. I've never gotten the benefit of the doubt. Heck, I can't even get anybody to address me appropriately in this court. No matter how many times I say it, I can't even get people to call me by the proper name that I've asked time and time again to be addressed by. But for some reason, people can't even understand that. So if I can't even have people address me by the proper name, how can I possibly expect to have a fair trial here today? But God willing, maybe God will open your hearts and minds and soften your hearts a little bit to see the egregious actions that people in this very room have performed, that are in fact egregious law violations, that's being ignored just to hold me accountable for what? making phone calls to a police department to complain about noise that is a law violation, or taking out of miscontext, or taking out of context rather, the malfunctioning of an electronic device. All in the guise, I guess, to cover up the truth, to silence me, to drag me through ridiculous court proceedings and harassment, and to be held in holding cells in the jail for 50 hours without a phone call, without any contact, without any help to get out, to get bailed out. Couldn't even get cooperation from officers, correction officers or police officers, to get phone numbers so I could contact family to get help, so I could get out and get prepared for hearings and so forth. I mean, if we are truly innocent until proven guilty, how is it that anybody's considered innocent and treated in that manner? It's absurd. It's absurd, but yet we sit here today as if I'm some type of violent person, treated as if I'm some kind of terrorist, when there's no proof or evidence of any of that. It's all conjecture, it's all hearsay, all based on lies and fraud that's been perpetrated since 2018 by the very police department and the very police officers that are alleging that I committed some crime, to charge me with a ridiculous crime, to, I presume, cover up their own crimes. But we'll hear and see all of this throughout these proceedings, and let the evidence stand on the record for itself and prove what the truth is. Because the truth is the truth, no matter what we believe, no matter what we say, no matter how many times we say it or how many people believe it. It doesn't change the truth. It doesn't make something untrue true. So, the best that I can hope for and pray for is that today we can have some kind of common sense and understanding to get to the truth, to get to the bottom of what's really transpired, what really got us here to this point today. This isn't about a simple phone call or a couple phone calls or somebody taking something personal or out of context. This is about cover-up of egregious corruption within the Zanesville Police Department. And that is why I'm being drugged through these processes and these court hearings and treated the way that I've been treated. Not as if I'm innocent until proven guilty, but as if I'm guilty. It's impossible for me to understand how anyone can look past their own faults and their own law violations, their own crimes, and expect to hold somebody else accountable. I mean, as a young man, I read a scripture in the Bible about how can you remove a splinter from another man's eye if you have a plank in your own, something to that effect. It's impossible. So for me to be sat here and treated this way and to answer for crimes that I didn't commit, that are impossible to be proven, well, it's just more proof of the fact that it's easier to ignore the law than to pay attention to it and to enforce it. That's why I'm sitting here today. So I hope and I pray that God will soften your hearts so we can get to the actual truth here of the matter and not be distracted by lies and nonsense and hearsay. But let's get to the facts. Let's get to the truth of the matter and understand what's really going on here. Because nobody should be treated the way I've been treated by this police department, by this court, by this city. This is outrageous. And regardless of what you people do here today, those crimes will be held to account by a higher authority, by a higher court. In fact, the very things that are going on here every day are being witnessed and being paid attention to by the authorities. So I would strongly suggest that all of you pay attention and mind your P's and Q's and make sure that you're not committing egregious law violations simply to drag me through a ridiculous process, because that's all on the record. And let me further caution everyone here today that those law violations on the record will have to be answered for in one way, shape, or form or another to the respective authorities. So hopefully we can come to a agreement today and an understanding of what the truth is, what actually transpired. And if we can do that, then I think you'll find out that I'm innocent of these ridiculous accusations. And then we can begin to expose what's really going on and why I'm really here. And that's all I have to say.
Okay, thank you, sir. Mr. Herbert, you may call your first witness.
Thank you, Your Honor. The city calls Detective Tom Porter.
Raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth to help you God.
Yes, sir, I do.
Yes.
Please state your name for the record.
Tom Porter?
And you understand that you were sworn to testify truthfully here today, correct?
Yes, ma'am, I do.
And you are a detective with the Zanesville Police Department?
Yes, ma'am, I am.
And how long have you been working in that capacity?
As a detective for 8 years.
And were you requested to investigate calls made from Brandon S. Killeran to the Zanesville Police Department in
Yes.
the course of your capacity as a detective with the Zanesville Police Department?
Yes, ma'am, I was.
And is Mr. Killeran seated in the courtroom here today?
Yes, he is.
And is he seated here to my right?
Yes, he is.
Who requested that you launch this investigation concerning calls made by Mr. Killeran?
Captain Phipps.
And these calls that were assigned to you to investigate were being received by our dispatch?
Yes, ma'am.
And where are the dispatch calls received?
332 South Street, Zanesville, Ohio, in this building directly across the hall.
And that is obviously inside the city of Zanesville, correct?
Yes, ma'am.
Generally speaking, what type of information did you receive prior to your formal investigation?
I've gotten emails that have been forwarded to Captain Phipps, who oversees not only the Detective Bureau, but he also oversees the dispatch center. The emails were from dispatchers complaining of the numerous calls they were receiving from Brandon Killeran throughout the evening hours, often complaining of noise, sometimes vulgar, disrespectful communications. Then I was able to, utilizing the resources, pull those calls and listen to them myself.
And when we're talking about the manner of the calls and the reason for the call, were they numerous in nature?
Yes.
Was that also a concern that was expressed in your discussions with dispatch and Captain Phipps?
Yes. 2 to 3 times a night, they were getting the calls.
And as a result of that investigation, Mr. Killeran was subsequently charged with 2 counts of telecommunications harassment. Is that correct?
That is correct.
And a 3rd count was later charged by you on August 10th of 2020. Is that correct?
Yes, ma'am.
You understand those are 2 separate cases?
Yes, ma'am.
You understand that before the court at this time is the case ending in 832, which is the August 10th of 2020 case, correct?
Yes, ma'am.
So in the course of your investigation that led to the original 2 charges, what type of contact did you have with Mr. Killeran?
I requested a warrant for his arrest. I was present when that warrant was executed and the arrest was effected. I spoke with Mr. Killeran at the Zanesville City Jail, just trying to communicate with him my role in this investigation, and that there was other avenues to sound his complaint, even taking him home after he was released from the jail.
All right, So you had face-to-face contact with him in the course of his arrest, detainment,
Yes, ma'am.
and you actually transported him back to his home once he was released on bond?
Yes, ma'am.
Okay. In the course of that contact, did you familiarize yourself with Mr. Killoran's voice?
Yes, ma'am.
Okay. And did he have your number here on station?
Yes, ma'am.
Okay. How was that provided to him?
It was provided in the form of a business card, and because I had taken his property, a firearm, and gave him my contact information so that he would have a point of contact about that property.
So after the charges were brought in the case number ending in 762, the original 2 counts, did you have ongoing contact with Mr. Killoran?
Yes, ma'am.
And when is it that you actually transported him to his home after he was released on those original charges?
It would have been the date of his arrest, if I could check my
Sure.
notes. I believe it was, I'm sorry, I do not have that date, whatever day that he was arrested on that original case.
Okay.
That was the date that he was transported.
By you?
Yes, ma'am.
Okay. So after that case, did he have any contact with you in
Yes.
person or otherwise?
Yes, ma'am.
What type of contact?
It was voicemails to my work phone, 740-455-0605.
And that was a number that you provided to him?
Yes, ma'am.
And were you encouraging contact with Mr. Killoran at that time?
No, ma'am. It was, my only encouragement was if he had questions about his property.
Okay. And where is it that you physically receive your voicemail?
34 South 4th Street, in Zanesville, Ohio, Stanton County.
Okay. Inside the city, correct?
Yes, ma'am.
And what type of voicemails was Mr. Killoran leaving for you?
Lengthy, complaining about the noise, if I wanted to come up and listen to the noise. And sometimes there would be music playing, but mainly complaints about the noise that he was hearing.
And were these similar to the calls that you reviewed in your original investigation?
Yes, ma'am, they were.
Same type of complaints?
Yes, ma'am.
Now, were these all voicemails, or did you ever actually take a live telephone call from Mr. Killoran?
I never took a live conversation with him until the 28th of July.
And who initiated that?
He did, Mr. Killoran.
So he contacted you on July 28th,
Yes, ma'am.
and you answered the phone at that time?
Yes, I did.
And do you have caller ID?
Yes, I did.
Were you aware that it was Mr. Killoran, or at least a number linked to him prior to answering the call?
Yes, I recognize the number.
And when you answered the call, did Mr. Killoran identify himself?
I can't recall if he identified himself, but I recognize the voice as being that of Brandon Killoran.
In addition to the voice, you also recognize the phone number, is that correct?
That is correct.
And how is it that you recognize the phone number?
740-221-4835. I've seen it countless times.
Okay. And that was the number that was shown on your caller ID on that date?
Yes, ma'am.
And when you answered the phone, what was Mr. Brandon, or Mr. Killoran calling concern?
About the noise, and he was highly agitated, complaining about the noise, which time knowing that, or at least feeling like the conversation wasn't going to be end peacefully, I asked him to have no further contact with me about this issue. I told him that just quit calling this phone, period.
Okay. Prior to that, had you had any warnings or told him not to call you?
No, other than just telling him about calling it for his property.
Backing up the voicemails that he previously left, were any of them harassing or containing any vulgar language?
Can't recall if it was vulgar language, but they were repeating the same thing over and over again about incompetent investigations. If I wanted to be a more competent investigator, I would come up and listen to these noises, but they were, yes, degrading.
So, during this conversation on July 28th, 2020, did you instruct Mr. Killoran to not further contact you at this number?
Yes, ma'am.
And did he acknowledge that request?
I believe he did. We ended our phone conversation at that time. So.
Subsequent to your
I object, sir. That wasn't a clear answer to the question. On whether could you re-ask the question, please? The last question.
Do
do you want me to re-ask the question?
Please.
Whether or not he acknowledged that verbal warning that was provided on July 28th of 2020.
And what was your answer?
I believe that he did because we ended our phone conversation shortly after.
I object on the basis that's not a definitive answer, sir.
Okay, well, I note your objection. I mean, you're objecting to the witness's answer. I'll take that into consideration, but I understand.
May I continue?
Mm-hmm.
So shortly after that conversation, the call ended, correct?
Yes, ma'am.
Now, subsequent to that verbal warning provided to Mr. Killoran on July 28th of 2020, did you have any contact with Mr. Killoran?
Yes, ma'am. I continue to receive voicemails.
Okay. And did you save these voicemails that were left on your phone?
Yes, ma'am, I did.
And did you provide these voicemails pursuant to discovery requests filed in this case?
Yes, ma'am, I did.
I'm going to play you what I'll reference as Exhibit A.
Hey, what's up, Howard? Hey, so check this out.
I'm going to pause this for a moment. Does this appear to be the beginning, a true and accurate copy of the recording that was left on your phone?
Yes, ma'am.
Okay. And do you recall the date of this recording?
August the 8th, approximately, 2020, approximately 6 a.m.
Okay. I'm going to play this now in its entirety.
Oh. So, hey, what's up, Howard? Hey, so check this out. So, the fact that nobody out here is bothered by any of this tells me that they are hearing impaired, and I am not. That's why I am. So here's something for you and your little shitty brain to investigate. How about the fact that you guys are fucking stupid and can't understand basic, simple concepts? Why don't you investigate that? Clearly, these people out here are hearing impaired if they can't hear properly, and so are you. So you might want to get your ears checked there, fuckstick.
So is that recording truly and accurately reflect the entire voicemail?
Yes, ma'am.
And do you recognize the voice that is associated with Exhibit A?
Yes, ma'am, I do.
And who do you associate that voice with?
Brandon Killoran.
And was this voicemail, which we've again labeled as Exhibit A here today, that was left on August 8th of 2020, was that the first contact after your verbal warning on July 28th of 2020?
No, ma'am.
Okay.
There have been approximately 10 previous calls.
So based on his ongoing contact with you after the verbal warning, did you issue him a second citation or a third citation for telephone communications harassment?
Yes, ma'am, I did.
And how was that served upon him?
I had requested a warrant for his arrest. Shortly after the warrant was signed, was on patrol, was in the vicinity of his residence. I drove by and observed Mr. Killoran in his garage working on his vehicle.
Did you confront Mr. Killoran at the time of this citation with the voicemail that he had left for you?
I advised him about, that was the voicemail, yes.
Did he make any admissions or denials at that time?
No, he did not.
I have no further questions for this witness, Your Honor.
Okay, so you have the option to cross-examine Detective Porter.
Yeah, give me 1 second, sir. Excuse me. How are you doing today, sir?
Good.
Well, thank you for being here. which could be under different circumstances, but it is the way it is. So you stated that you've been a detective for 8 years, is that correct?
That is correct.
All those 8 years with the police department here in Zanesville?
Yes,
Have you worked for any other police departments or just here in Zanesville?
just here in Zanesville.
So now, on the issue of the telecommunications harassment, you said that Captain Phipps had assigned you to that investigation, correct?
Yes,
Initially. Do you remember the date that that he assigned you to that case or to the investigation?
I do not.
Do you feel, sir, that you have a good grasp on the law, what the laws are, and how to interpret the laws?
I do.
So, are you aware of noise ordinance laws here locally, sir?
I am.
Are you aware that any noise that violates those laws, or let me rephrase that. Are you aware that any noise that's being emitted or transmitted during the hours stated in that law is a violation of the law? You understand that, correct?
There's an ordinance that it's rather specific, I'm aware of, yes.
Right. During certain hours of the night, there's supposed to be quiet. There's not supposed to be any noise at all. That sort of thing, correct?
I'd have to look at it. I'm not to quote.
I understand, but just in general, that's your general understanding, correct?
Yes.
So when you were put on the investigation of the situation, did you actually investigate any of the actual noise that was being reported?
I was not assigned to investigate noises. I was assigned to investigate the numerous calls that were being made to the Zanesville Police Department.
Right, but in doing that investigation about the phone calls, at any point in time did you investigate the reason why the phone calls were being made, what the reason was? To your knowledge, has anybody from the Zanesville Police Department actually investigated that matter, what these noises are that have been being called and complained about?
I'm not aware of what everybody else investigates. Sorry.
But I'm just saying, you're not aware of any investigations, correct?
I know officers have been, I take that back. I do know officers have been up there and have reported not hearing anything.
Okay. So I have to ask, sir, how, if a noise can be recorded and played back, or if other people besides Zanesville police personnel go to the location and hear the noise and can explain it the same way that I or anybody else does that witnesses the actual noise that's being reported, if the people not associated with the police department can hear the noise and hear the recordings and acknowledge the noise, but the police officers can't acknowledge the noise or hear the noise or whatever the excuse might be, wouldn't that constitute some type of negligence?
Your Honor, I'm going to object. This calls for a legal conclusion. The officers already testified that he has a lack of knowledge concerning prior investigations in this case.
If you want to rephrase your question.
Just give me a second. Let me think about how to rephrase it.
Sure.
Would it be responsible for anyone to ignore proper evidence or proper evidence? Would it be? Apologize. I'm just trying to think how to word this. if people not associated with the Zanesville Police Department are able to hear the noise that's being complained about, or the complaints are being filed about, rather, but Zanesville Police Department personnel cannot. I mean, you don't see a problem with that?
Your Honor, I'm going to object. This calls for speculation.
He's asking for his opinion. You can give your opinion.
If the officer doesn't hear it, he doesn't hear it.
But okay, so I'm just trying to understand here. So if the officer doesn't hear it, but men and women who have nothing to do with the police department are able to listen and hear it, I mean, all that basically would constitute is that it's different hearing abilities, correct? Please stop. It just means that maybe the police officer couldn't hear. Maybe the police officer has hearing impairment where they can't possibly hear the noise. I mean, wouldn't that be a possibility?
I don't know it could be, possibly, I don't know.
But with that being said, just because the police officer can't hear the noise, does that mean there's no noise?
I don't know, I wasn't there.
But no, I'm just saying, if there's a noise that can be recorded.
Your Honor, I'm going to object. This is argumentative at this point, and he's answered the question.
I believe he's answered your question. He said he wasn't there. He didn't hear it. Any questions about what other officers could hear or not hear would be speculative.
Right, I'm not expecting him to answer for anyone else. I'm just asking his personal opinion on the situation. That it's odd to me. It's odd to me, and that's what I'm just trying to get to the understanding of how.
If you'd like to ask his opinion on proper police investigative procedure, you can certainly ask that. He's a detective and can have opinions on that. But if you're asking him to speculate on what other officers have done or may not have done, that would be speculation unless he has personal knowledge of those investigations. So
Okay, well that makes sense.
You're asking us questions.
No, that does make sense. So, I guess with that being said, then, so would it matter if I don't put it in the context of the police officer? What if it's just two other individuals, one that can hear it and one that can't? Is it the same?
Try to ask your question and see if it gets objected to.
So if I have a man and a woman, man comes to my property and witnesses the noise and can hear it. The woman comes to my property and witnesses the noise and says she can't hear it. Is one right and one wrong in that situation? I mean, I mean, what would be your reasoning with that, or what would you be your thinking that, rather, if that's the proper way to state it?
If one heard the noise but the other one didn't,
Yes.
you're asking me.
Does that mean there's no noise? If one person can't hear the noise, so if the woman comes to my house and says that they can't hear the noise, does that mean that the woman is correct?
It's not bothersome to her then.
Well, it's not. It doesn't make it. It's irrelevant whether it's bothersome or not. It's just a matter
Your Honor,
of.
I'm going to again renew my objection that this is both speculative and argumentative at this point, and I think we need to move on.
I'm not sure what you're driving at right now. The question to him is quite speculative. He's not an expert on noise or sound. If you're asking him an opinion as the police investigation, you can certainly ask those questions.
That's what I'm trying to get to. I'm having a hard time wording it so I can have him understand it appropriately. So basically,
I know you don't want to take advantage of this, but you do have standby counsel. She may have an idea on how to help you ask this question.
I would be all for that, sir, except for that might be misconstrued as my waiving of any of my rights.
Sir, it's not going to be construed as anything other than you taking advantage of your standby counsel. She is not your representative. You're representing yourself. She may have an idea on how to help you with these questions. That's the purpose of her sitting by and listening to these proceedings.
Well, I mean, I understand that's what you're saying, but there's been a lot of things that's happened throughout these proceedings that have been questionable. So
I'm not trying to force you to do anything, sir. reminding you that you do have standby counsel. She is trained in asking questions, and she may have an idea on how to help you ask these questions and make the points that you're trying to make.
Okay, we'll just move on. So when it comes to an investigation, for example, when you were placed on this investigation by Captain Phipps to investigate the multiple calls, the complaint calls about the noise, would at any time throughout the investigation or an investigation like that, normally would you investigate the reasoning behind the cause or what the motive is for the cause, if you will? I don't know if I'm explaining that or saying that right.
I think I get where you're going. The caller, you, stated numerous times why you were calling.
Right.
And I was investigating the criminal act of telephone harassment. So
right.
Therefore, that was my sole objective, to investigate the telephone harassment.
Okay. But, and correct me if I'm wrong, but in an investigation, shouldn't you consider all pertinent evidence and facts on the investigation?
I did.
But if you didn't investigate the reason for the calls and didn't fully understand what the reasoning for the calls were, I mean, maybe, I don't know, I'm having a hard time understanding that, how if you were looking at all the evidence, how you didn't look at the evidence of the reason why the calls were being made in the first place.
I looked at the evidence that the city law director sent you a letter that stated to find other avenues and not to utilize the St. Hill Police Department as that avenue. And continue to do that. That was my investigation.
Okay. Now, with that being said, sir, are you aware of Ohio Revised Code and the laws that the state sets forth for the occupants of the state?
Yes.
Are you aware that there are state laws that actually govern actions of the city and the local government in certain special situations?
Yes.
Are you aware of a law, Ohio Revised Code 3767?
No. I'd have to look it up.
Ohio Revised Code 3767. It pertains to nuisances. I've forwarded this information to the police department, to the public safety director, to the chief of police. Not quite sure if I've sent it directly to you or not during that investigation. There was never any actual questions posed to me during any of your investigations, so I was completely unaware of any investigations that you were performing. But just for the record, Ohio Revised Code 3767 pertaining to nuisances, it explains very, very specifically how the city is supposed to handle nuisance problems when they're not located in the city. So like for example, for this situation here, the reasoning for the calls, it was for noise that was being emitted from outside the city in the county area, that the noise was enveloping the city neighborhoods, which that in fact would make it a violation of the law. Because as the noise...
I'm going to object, as this isn't a question and some more testimony from Mr. Killeran at this point in time. It needs to be stated in a question form.
I understand. I know you're giving some pretext.
Context, exactly. Okay. Well, I mean, I guess with all that being said, I mean, you did say that you're not aware of this law, correct? 3767 pertaining to nuisances and how it states how the city is supposed to handle situations in the county?
I'm aware of the law. I wasn't aware of the ordinance or the code.
Okay.
When you cite it, I'm aware of it, yes.
You're referring to the state law?
Yes.
Okay. So at any point in the investigation that you performed, had there been any discussions at all about the noise itself, or what could be possibly done about that issue and the reason why the calls were being made?
No.
So let me read here. In Ohio Revised Code 3767.13, prohibited acts.
I'm just going to remind you, you can read it if there's a question to follow, but you just can't read the law into the record, okay?
Okay. Well, I mean, I guess it's a moot point for me to read it, because if you weren't fully aware of it, and at the time, and even to this point now, and
Sir, you can read it to him if you have a question with regard to the statute. I'm just saying, you're going to have an opportunity to testify should you choose to testify. But right now, if you have a question regarding that statute, I don't have a problem with you reading or quoting portions of the statute in order to ask him a question. Just reminding you, you have to ask a question, okay?
I got it, thank you. Okay, so I'll read this here real quick. So in Ohio Revised Code 3767.13, prohibited acts, in subsection D, delta, it states that persons who are engaged in agriculture-related activities, as agriculture as defined in section 519.01 of the Revised Code, and who are conducting those activities outside a municipal corporation in accordance with general accepted agricultural practices and in such a manner as not to have substantial adverse effect on the public health, safety, or welfare, are exempt from divisions A and B of this section from any similar ordinances, resolutions, rules, or other enactments of the state, agency, or political subdivision, and from any ordinances, resolutions, rules, or other enactments of a state, agency, or political subdivision that prohibit excessive noise. Now, I mean, there in the law, it's referring to excessive noise. It refers to well, let me rephrase this. So you said you weren't aware of the law. So were you aware that there is actual laws on the books that allow the city to address noise violations in the county?
I'll clarify the first part. I was aware of the law. I wasn't aware of exactly what, when you quoted it as the ORC number. Okay. So to address that, I was working, again, an investigation for telephone harassment.
Sir, do you recall back in 2019, roughly August of 2019, it may have been August 22nd, I believe was the exact date, where there was a situation with the Zanesville Police Department where officers had contacted the VA on my behalf and had given VA personnel information regarding me and my supposed mental state. Do you recall any of that?
I don't recall the date, but I do recall something being mentioned, yes.
Okay. Now, back in that time frame, I was actually, just so you're aware, I was actually what they call pink slipped. I was given a writ for involuntary admission because of information that was being passed to the to VA healthcare representatives. Did you have any involvement in any of that activity back then?
I spoke with a doctor over the phone, I believe.
What was that again? I'm sorry?
I spoke with a doctor over the phone, I believe.
Do you remember what the conversations were, or what you had said to the individual?
I do not.
Okay. Are you aware of any of the actual accusations or the information that was provided to the VA personnel to from the police department.
Your Honor, I'm going to object. I understand that this is cross-examination, but this is not relevant to these proceedings, and Detective Porter's already established through his testimony the scope of his investigation, and this is well outside that scope.
Well, actually, sir, this is all context for exactly what we're here today for. I have an excerpt from my very medical records of those conversations.
Explain to me the relevance of this line of questioning.
Well, actually, no, I guess I could be saved for my testimony.
Okay. I'm not ruling on the objection. I'm asking you to respond to it. If she's objecting based upon relevance, I've asked you to explain the relevance of this line of questioning for this witness.
Yeah. Well, in context, that's what.
That's fine.
Right. It's just as far as establishing the context and the history of what's transpired to get us to this point today, and what led up to the fact of the phone calls that the gentleman was investigating. So I'm just trying to establish all the facts around that and what actually transpired, what was actually investigated, what wasn't, what was actually known, what wasn't, what we actually have proof and evidence of, and what we don't, what's all just speculative or hearsay or somebody's opinion. Or I'm just trying to establish those facts.
Okay. Well, I'm going to sustain the objection at this point. If you want to bring it up in your testimony, you can certainly do
that. Okay. So we're going to fast forward. We'll fast forward back to more current events. So in the initial charges, and I guess what was it, the first two cases that were created off of those first two charges, if I'm stating that correctly, you were involved in that process as well, the investigations of those charges and such?
Yes.
Now, in your testimony, while the I guess prosecutor was questioning you, you had mentioned that you and I had several conversations in person,